Business Link acknowledges and respects that we are on traditional land, meeting grounds, territories, gathering places, and traveling routes of Treaty 4, 6, 7, 8, and 10, and the home to many First Nations, Métis, and Inuit people. In the spirit of reconciliation, we acknowledge the lands of those who have come before us, reside here now, and in the future. Welcome again to Protect Your Business. Let's talk intellectual property. Whether you're building a brand, developing a new product, or refining a service, understanding intellectual property or IP helps protect your ideas and gives your business a competitive edge. Today's session will help you to understand what maybe can be protected, how intellectual property rights work, and where you can start. And my name is David Beta, Manager of Client Services here at Business Link. If this is your first time joining a Business Link session, welcome. Business Link is a government-funded nonprofit that helps small businesses in Alberta to start, grow, and thrive. We offer free one-on-one business support, market research, training, and resources to entrepreneurs at any stage of business. Now I'm excited to introduce today's speaker, Carolyn Lefebvre, Intellectual Property Advisor with the Canadian Intellectual Property Office, or CIPO for short. Caroline has been part of CIPO's IP awareness and education team since 2007. She works closely with entrepreneurs, creators, students, and innovators to help them understand how to protect and leverage their ideas. She is deeply passionate about making IP easy to understand and accessible for all business owners. So Caroline, thank you so much for joining us here today. Now over to you. Oh, I think you're just muted there, so we'll give you a chance to.
I've just unmuted. Thank you so much for that great introduction. Um, Presentation uploading right now. So yes, thank you so much. And as David mentioned, when you ask your question, please keep them generic. If you have any specific questions, I'll provide you with a link at the end of the presentation for you to contact me directly and have this one-on-one conversation. So you don't disclose any information that could be detrimental for you to you getting IP protection later. So land acknowledgement. I'm based in Ottawa-Gatineau, so it's the Anishinaabe unceded territories that I'm sitting on right now. So, and I'm really, really happy to have this chance to meet with you guys, even though it's virtual. So I'll start with clearly I didn't change my date, so sorry, the date on the presentation is wrong, but it'll be changed later because I'll provide you with I'm trying to, for some reason, um, the slides are not changing for some crazy reason. Oh, okay, perfect. Now it's working.
Yeah,
Okay,
it's working. Yeah, we can
excellent.
see it perfect.
Okay,
Yeah.
yes. So you should have CIPO's mandate in front of you. Okay,
Yes, we.
perfect. And please ask your questions as we go during the presentation because I really want to make sure that the concepts I'll be sharing with you are understood. And yeah, so because sometimes IP regulations, legislation can be a bit arid, so don't hesitate to ask questions as we go. So CIPO, the Canadian Intellectual Property Office, the main mandate of CIPO is to grant IP in Canada. So we have examinations team for trademarks, patents, industrial designs, and copyrights. And you'll see later what each of these protect, their length of protection, relative costs, and value. I am part of a team that raises awareness and effective use of IP by Canadian innovators, SMEs, as David mentioned. So my role as an IP advisor is sadly not to provide advice, but we do demystify what IP is, how it could apply for your project. Now, I mean project. It's could be a creation, could be an invention, could be a fiction book that you wrote. It could be a logo, could be anything that helps you protect your business. So what we do is we provide one-on-one sessions, all for free, and there's no limit. You can meet with us as often as you wish. We have webinars such as this one today. We attend conferences, we attend panels, we connect with partners all across Canada for us to better reach anyone who has a project and needs to learn about IP. So what is IP? Intellectual property, IP, starts with an idea. Keep in mind that as long as it's in your head, it's not protectable. It becomes protectable when it's on a tangible support, which means computer code, a logo, a book, a sculpture, a new technology. It has to be concrete, and then we can decide on which IP rights would be applicable for the project. Just want to, okay. So quickly, today we'll talk about trademarks, patents, copyrights, industrial designs, and trade secrets. Plant breeders' rights are not protected at CIPO. It's with the Canadian Food Inspection Agency, and it's to protect varieties of plants, trees, fruits, vegetables. Is the chat, okay, are you, just to make sure, okay, perfect. Yeah, so I'll be monitoring the chat, and I know David will help me with a Q&A. So where and how IP can be used. So if you're an inventor, if you're an artist, if you're a business owner, chances are you might need IP at one point in time. And we'll see sometimes it may not be super critical to have IP protection, but sometimes it is. So let's say you're developing a new technology. You're developing an application that could be used with a phone. You could protect that by patents, by trade secrets, by copyrights, by industrial designs and trademarks. But some other projects are more specifically protected by only one IP right. Let's say a logo would be a trademark. The name of a product would be a trademark. A computer code would be copyright, probably more than likely. So my conversations with clients is to identify what is it that you have and how intellectual property rights could help you achieve your business objectives. So why is IP important? For many reasons. And I'll start with a concrete example. Let's say you're manufacturing, you love ski, and you decide to go into the downhill ski market, and you develop this super cool, super innovative downhill ski boot. The shape is very, very different. It's lighter material. It warms longer and faster. You have a cool slogan. You have a cool name for that boot. So you're ready to launch. And your business objectives is within 10 years, you want to be the official provider of all the Canadian Olympic teams, but also other Olympic teams around the world. So that's your business objective. Let's start with that. So you develop that really cool downhill ski boot. Are you sure it's really innovative? And you'll see why. What you want is to make sure that what you're developing puts you at the edge of your competitors, that you have something that differs you, that makes you better than them. So you'll develop, a new feature. You'll develop this, as I said, this really cool design or cool logo. And to making sure that you're very innovative and creative, you'll have to do research prior to developing, doing the R&D, and prior to protecting. So it's all along the cycle. So you will check different IP databases. CIPO and other IP offices around the world do provide free accessible databases. Check check websites, check internet. Make sure that the new technology does not exist. Make sure that the logo, the slogan you've developed does not exist either. Because what you want is to protect what puts you at the edge of your competitors, what makes you better, what makes you different, what aspect of that boot on the technology side makes it better, makes it more efficient, warmer, more comfortable. That's what you want to protect by one or two, three, four IP rights. So you're 100% sure that your ski boot is vetting, that everybody will want it. Elite skiers and day-to-day regular skiers. But now you're like, okay, I need financing because I need to export my boot. I need to open markets. It's going to be expensive. What you have to realize is that more and more federal, provincial funding programs, banks, investors, angel investors, venture capital, they will rely on your IP strategy to provide funding. Why is that? And as we'll see later, is because an IP strategy and IP rights will provide you with an exclusivity in your targeted markets. So as a potential investor, if and David, I'll use it as an example because I see you. David is the one developing the new booth and he's looking for funding. And I'm an investor. Let's say I'm a dragon. And I'm looking at David and I'm like, your boot is really cool, but have you filed for patent protection? Have you filed for trademark protection? And David is like, you know what? No, I want to give it to the world, anyone can use it. Then as an investor, I'm less inclined to invest because if someone else is more is more aggressive on markets, they would be selling more of David's booze than he is. So I'm going to invest in the guy that sells the most. But if David has a really strong IP strategy, knowing exactly in which country he's going to file protection, that he's got patents and trademarks and industrial designs lined up, then it demonstrates that he's serious in his business and he knows what he's talking about. So I'll be more than inclined to invest in his project. Same with federal government funding programs. They are looking for an IP strategy. And I always tell my clients, don't be afraid. An IP strategy is not something like 50-page and you can't change it. No, an IP strategy is very briefly stated as what you need to protect, when and where. And it has to be agile. You need to be able to adjust your IP strategy, same as your business strategy, because who knows, some partners may come up, new countries might arise, some partners may go bankrupt. So you need to always realign your IP strategy. So you've got your IP strategy. You obtain your financing from different sources. And now you're like, okay, I want to make sure that I am achieving my business goals. Look at your business goal, your business objectives as a big umbrella, under which you have different strategies: IP strategy, marketing strategy, R&D strategy, HR strategy. All of these are equally important, but different times. And you need to balance these strategies so that at the end of the day, you're achieving your business goals. And so you need to invest in qualified people, you need to invest in equipment and IP strategy, you need to invest in many, many aspects of the business to achieve your business goals, and IP is definitely one of them. So going back to the example, you're like, okay, it's a winter sport equipment, so I'll focus my business strategy in northern countries where there's ski teams, where I have contacts with the Olympic teams, whatever it is, but I'll focus my strategy in about 10 to 15 countries. And you'll see why. IP protection is territorial. So if you protect something in Canada, either by trademark or patents, it's not protected in other countries in the world. So you'll have to identify in which countries you want to be proactive and you'll be active, and you need to obtain that protection. So at the end of the day, you've developed your booth, you're connected with all the Olympic teams, you've got a good reputation, and it goes on and on. And your reputation is increasing, is improving. People rely on your technology. So at the end of the day, you will more than likely develop new products. Could be skis, could be poles, clothing, etc. But your reputation is there, and it's based on the branding, on your trademark, and on the technologies you've developed, on what you're offering that responds to a need. So people will keep talking about you, and your reputation will increase, and your collaborators and clients might increase as well. This is what you want, and this is why you need to protect what you're developing by IP. Any questions so far, or we're good to go? Okay, I'm monitoring also the Q&A. So when I said that IP provides an exclusivity, it also helps you to prevent or to have recourses against anyone who would use your brand negatively, which would have an impact on your reputation. It would be detrimental to your reputation, making you lose clients, That's the last thing you want. If you've spent years and efforts and money to develop a new product, a new service, the last thing you want is someone infringing on it. And you certainly don't want anyone to make money on your back. So the value of IP, one of the value of IP is that it gives you recourses to signify, but also to fight or to go against infringement and negotiate with the infringing party. This infringing party could become a partner because if they use your technology, it's because they need it, they like it. So instead of fighting in court, maybe negotiation will lead to an agreement between you and the infringer. Maybe they're opening new markets for you. Maybe they're in the total different field of activity. So maybe instead of being a player strictly in the ski equipment, let's say you manage to have a collaboration in something very different in the car equipment, let's say. So you never know where opportunities can arise from. And by having IP properly managed and aligned, you're well positioned to increase your market share and to negotiate with potential collaborators and partners. Common mistakes to avoid: waiting too long to start protecting IP. For a couple of months, we've been talking with my colleagues, and we came up with this slogan that says it's never too early to think about IP, thinking that, you know what, you may be in a very start of your business journey, and it's never too early to think of a really cool name, a very good logo, and to protect it ASAP because before someone uses the same name, which is something you don't like, you don't want. And you don't want to lose any IP because you don't understand you have it. That's such a common mistake. I often hear, oh my God, I developed this new thing and oh, someone else has it. Or someone is infringing, but it's too late for me to obtain my patent. And you'll see why. So it's really important to talk to anyone who knows about IP, starting with CIPO IP advisors, and then we can lead you to better understand the system, when you should file, and when you should meet with an IP professional that provides a legal advice that we can't provide you. Infringing on someone else's IP is also a risk. Sometimes, most of the time that I've seen, infringing on IP is done in total good faith, in the sense that you don't know it's protected and you're using a technology or you're developing a logo or a name and you don't even know it's in use. So that's why, going back to what I said previously, is do the research on IP databases and on the web in general, just to make sure that what you're developing is not infringing on someone else's IP. Super important to see also is ensure that you have all the documentations to confirm that you are the owner of the IP, if that's the case. By and large, without being too technical, in Canada, with the Labor Act, any IP created in the course of a work that's paid by an organization or an individual belongs to whoever pays, unless the contract says otherwise. But if you're hired to develop a new technology in a car equipment company, well, the car equipment company will be the owner of the patents or the initial design. You'll be mentioned as an inventor, co-inventor, but not as the owner. If you're a sculptor and you create new sculptures, you own the copyright because you are the one who develops them, and you might sell them, but you still own the copyrights on your work. So far, so good?
Yeah, I
Perfect.
think so. Yeah, we'll have
Okay.
some specific questions as we get through things.
Mhm.
I know they're hearing a bit of background noise, but probably not much you can do about that. But
Oh, I can. Maybe it's just because I didn't use the proper audio
I
setting,
think
which
they're
is
just hearing someone else. Yeah. So, but yeah, whatever you can do.
oh,
That,
I never know what to do here.
yeah.
Um, what's it? Video setting, audio setting. No, I'll do my best. Okay. Yeah,
Sure.
there's someone. Yeah, that's a part of being in the office instead of being at home, right?
Sure. Yeah.
All right.
Great.
So very quickly, a trademark is whatever protects your brand. And it's different also from a business name. If you're incorporated or registered, it's not a trademark protection. And that's a myth that I hear very often. So that's why I always start with mentioning this, demystifying trademarks and business name. So a trademark could be a combination of letters, a name, a word, sound, distinguishes guide, colors, scent, visual aspect. It's whatever distinguishes your product, your service from your competitors. A trademark provides exclusivity to its owner for 10 years in Canada. Most of the countries in the world are also on a 10-year basis. Some might be up to 15. And what's good to know is that trademarks are renewable as long as the trademark is in use on the market. So every 10 year, the owner has to renew their trademark applications. CIPO does not send reminders. So if you're the trademark owner, it's your duty to renew your trademark before it expires. So as I said, it's a combination of letters, words, symbols, sounds, and designs. In Canada, we do recognize the use of a trademark even though it's not registered. The difference is if your trademark is officially registered at CIPO, it's pan-Canadian, it's coast to coast to coast. So if anyone tries to use or register a very similar trademark or something that would come close and be very confusing, you can exclude them from using their trademark. If it's not registered for some reason, then the protection is very local. It's more like within your community, within the region, but not across Canada. So if you have an ABC clothing brand and you're based in Winnipeg, and then someone in Montreal is trying to use the same, it'd be more difficult for you to build a case and to prevent that person from using a very similar brand. Marking is important. It's not mandatory, but it tells the world what's the status of your trademark. So if you see TM from now on, keep in mind that it's not registered. Maybe it's in the process of being registered, or it's just not registrable, and we'll see in a few slides what's not registrable in terms of trademark. When you see R, it means that it's officially registered in the country where the goods and services are being offered.
And yeah, question,
Mm-hmm.
Caroline.
Yeah.
Um, Someone was just curious that, which is a good question, is a trade name versus trademark. And
Yes.
they mentioned they've registered a trade name. What options are available if someone else uses it without checking that it's already being used by them? And trade name, I know, doesn't have official name
Mm-hmm.
protection with it. So if you want to just quickly cover
Yeah,
that.
absolutely.
Yeah.
So a trade name, okay. So trademark has to meet some criteria, and we'll see. But trade name is the name under which a company operates. So it could be a name per se, or it could be Canada 1, 2, 3, 4, 5, whatever. In terms of trademark, what we call a descriptive mark is not registrable, especially if it's using also first name or last name. So let's say Carolyn's Beauty Shop would not be registered as a trademark, but it could be a business name. And the business name protects what I call your legal entity, what allows you to exist as a company, to receive funding, to have shareholders, to operate as a company. The trademark is really what the client sees, how your clients recognize you from your competitors, how they will decide to choose your product versus the ones of your competitors. Do you think, and I know, and I saw another question as well in the chat.
Yeah.
So someone was asking, what if you don't have $10,000 to trademark your brand? Okay, just the
I
good
don't think
news.
it costs that much usually.
No,
It's a
exactly.
little bit cheaper. Yeah.
And that's the good news. And that's also a misconception. If you file the trademark on your own with CIPO, it's $450 starting level, with different technicalities, but it's mainly about $400. If you hire a trademark agent that does the work for you, represents you with CIPO or USPTO or any other countries, it's about $1,500 to $2,000 per trademark, including the fees from CIPO. So it's not excruciating. I know it's money, but it's definitely more reasonable than filing for patent and for different reasons as well. Those are a very
And
beautiful art.
follow-up questions, can you use trademark multiple trade names in one attempt? Can we can we
Oh,
trademark multiple trade names in one attempt? Okay.
I'm, to be honest, I'm not a specialist in the mechanism to apply, but if you, let's say you file a name, you file a logo, slogan, at the same time, it's three different applications. And I know there's family names, so that would be more relevant for my, and I should know the answer, but it always escapes me for some reason. But it's more like my colleagues at Client Service Center that could help you, and I can give you the phone number 669971936. That's a kind of answer that you could get from my colleagues at
So,
the client center.
yeah, some of those specialized questions are
Yeah,
really, and
exactly.
they may direct you to like a
Mm-hmm.
trademark or patent agent, right, who has to kind of sit down and dive further into the case, right, to
Mm-hmm.
provide appropriate advice. Yeah.
Exactly. Um, okay, so Mary, I'm just quickly going through your question. If brother was an artist painter, passed away, and I have all of his paintings, I would like to sell his art, which he had intended to do, and I would have been assisting him to do so. With those funds to make a booklet of his art, so to continue with his legacy. How does IP copyright help in this case? Thank you so much. Okay, first, and we'll see later, but it's copyright, and copyright is applied automatically upon the creation of the work, and it lasts in this case, your brother's life plus 70 years. So copyright is still protected. And then we can have, and a quick question would be if you want to do a booklet of his art, then the booklet would be protected, but each of his separate artwork would be also protected by copyright. We can protect each and every piece by copyright, which is $63. Fees have changed recently, so I'm kind of lost track of the exact fees, but it's around $63, and it protects you. Copyright is only IP right that protects you across borders. It's recognized in 156 countries in the world. So does
Great.
that answer the?
I think
Okay.
so. Yeah. Thanks,
hmm
Carolyn. I'll let you continue with trademarks. I know you have a lot to
hmm
get through with the other
We do,
categories.
and it's fine. I'm here to until we've covered the topics. Um, Okay, so on this page, I kind of I start telling my clients, before you register a trademark, when you develop your trademark, your branding, your logo, develop something that you're going to like forever because you don't want to change this every 10 years. You want your client to recognize your branding as well. So when you apply for that protection, make sure it is what you want to be recognized at. Speaking of personal experience, I've got this really tiny company that I have, and I still haven't registered my logo because I like it. But do I like it for this logo to be mine forever? I'm not sure yet. So I'm kind of debating right now, and I'm waiting before I want to spend money to register my logo. As I said, trademark protection is territorial. So you have to identify in which countries you want to seek trademark protection. There's mechanism to apply many jurisdictions at the same time, but as a small business owner, as a startup company owner, maybe you don't have the financial means to apply in 20 jurisdictions. The good news with trademark in most of the countries, I mean, you can apply for trademark as you're developing your markets. You don't have to think right at once, oh my God, within 5 years, I need to be active in 20 countries. You can go as you're developing, as I said. You can file on your own. It's doable. I mean, it's doable. I've got companies that will do everything on their own. Some will prefer to hire a trademark agent. Pros and cons is if you do it on your own, you save money, but you're going to spend a lot of time drafting applications, answering examination reports that you may not be comfortable and used to do. You can hire a trademark agent where you will spend more money, but you can focus your energies and efforts on what you're good at doing, developing your business, finding clients. So it's really that's kind of conversation we can have, and we can prepare you to meet with a trademark agent and a patent agent. That's part of the work we do. Although we can't recommend an agent over the other, but we guide you through resources on where to find them. So why would you register a trademark? It really depends. You want to protect your trademark, so you get that protection, obviously. Um, but you may not need it. For example, if I were the owner of a convenience store in my neighborhood and I have no intention of franchising across Canada, maybe I don't need my trademark, But maybe if eventually I'm considering franchising and expanding my convenience store, maybe trademark is better for me. So it's a case by case, but most of the time you will protect your trademark to protect your branding, to make sure your clients recognize you and keep buying your product. And of course, to exclude any other one to use your trademark without your consent. Um, I'll go quickly on that, but when you apply for trademark protection, you need to identify what are you offering under this trademark. Is it food and beverage services? Is it high tech? Is it chemical products? Is it consultant services? Whatever it is, but it's fairly easy to identify. There's what we call the niche classification where we can lead you to, and you just identify which classes of service you are offering. So quickly, and then we'll jump into patents. To register a trademark, it has to be distinctive. What does that mean? It means that it cannot be confusing with any other existing trademarks on the market. And confusing means if the trademark is very similar, will clients be confused? And a good example of non-confusing trademark. Actually, 1 and 5 I realize are pretty much the same, but let's say you have three different trademarks with McDonald's: restaurants, cigarette manufacturers, and lawyer's cabinet. Examination claimed that there would be no possible confusion between the three because they're very, very different. Can use a name or surname because if let's say you trademark someone's name, then it means that anyone using that name, having that name in Canada, could not register their trademark unless it's been in use for so long that it's recognized as a specific trademark. Can't be descriptive, as I've mentioned before. Beauty salon, Carolyn's beauty salon, Carolyn's convenience store. It's too descriptive. It's not protectable. We can't use any other languages to describe goods and services. So if that's the case, you may need to think about English and French. Not confusing with it. And with an existing mark, as I've mentioned, you can't use your geographical location. So you cannot say Alberta's best beef, let's say. You can't. Okay. I'll rephrase that. You can use all these, but they may not be registered as a trademark. They will be just your name. You won't be registered, but you can still use and carry your business under that name. You can't also use a brand that is misdescriptive. And a perfect example is if you're developing a local courier services using trucks and bikes. You can't call it Air Express service because clearly you're not using aircraft to deliver mail within Calgary. Let's say you'll be using cyclists or car drivers. And you cannot also use what we call prohibited marks. Prohibited marks are what we call the official marks. So it's like the Canadian flag, coats of arms of an institution. You can't use those marks without the consent of their holder. So quickly, you'll get the presentation. That's the path of your trademark registration from when you apply to once it's finally registered. I would say within 2 years, which is not too bad. You can expect a first report after 9 months. Doesn't mean you can't use your trademark. It just means it's pending examination and registration. So there's always a risk that the trademark will be rejected. That's why we highly recommend at least to speak with a trademark agent at the very beginning of your process, just to make sure that the branding you have in mind has good chances and good potential to be protected. Because sorry.
Yeah, I really like that you went through that process because a lot of people think it's what is the name you'd like, and you put Caroline Convenience Store and you pay your fee and you're done.
Hmm.
And that's not the case, right? You can
No,
see
exactly.
criteria, the process. It can take upwards of 2 years. Like there's a lot of work that really goes into
Hmm.
the trademark. So I'm glad you're really
Hmm.
highlighting that, right? It kind of just shows the process, a journey.
Hmm. Absolutely. And I would say trademark applications don't get accepted right away. There's always that negotiation between the examiner and the applicant or their representative, just to make sure that at the end of the process, your trademark protects your brand legally and on the marketing side as well, so that you really define that scope of protection that will be useful for you to defend your trademark in case of infringement. I see, just to make sure. Okay,
Yeah.
perfect.
We have a question
Yeah.
relating to trade name.
Mm-hmm.
We have trade names we have registered as copyright. Is there a problem with that? Did you want to wait to the copyright section?
No, I can answer that right away. We have trade
Okay.
names, we have Richards as copy. Well, the thing is, a copyright does not protect the name. Copyright will protect the content of a book, of a source code. So your trade name should be protected, registered by either federal or provincial registration, not by copyright. So yeah, which is yeah. So no, it's not the same thing. So you will need to do another application with the Alberta, which organization in Alberta registers business names. It's
Uh,
the name
Alberta
exchange.
Registry, but it's privatized. They're
Okay.
privatized, so it's different offices. Yeah.
Oh, gotcha. Okay,
Yeah.
interesting to know. Okay, excellent. Giving the time, I will jump into patents right now. Um, okay. So, any question on trademarks before we jump into patents, just to make sure it's
I think we covered the main stuff.
perfect.
So, yeah.
Okay. So patents will protect a functionality, a new technology, an element that provides a solution. And it's valid for 20 years from the date of filing, and it's not renewable. It's 20 years, and after that, it's public domain, and that's valid for all the countries around the world. There's some very, very limited exceptions, but by and large, patent lasts for 20 years. We consider after 20 years, the technology is probably obsolete, so there's no need to maintain your patent alive 20 years from the date of filing. So what does it protect? So as I said, it's a functionality, it's a solution, and it's got to meet three criteria. It's got to be new to the world. Even if you're filing strictly in Canada and the States, let's say, if that technology, that solution exists elsewhere in the world, you won't be able to get a patent. You will need to improve on that existing technology solution to obtain your own patent. It has to be useful. It has to provide a solution. It has to be practical. It has to work. The example we use as a non-useful invention is the perpetual movement machine. There's no use to that. It could be fun, but there's scientifically no use for that. And the what are the third criteria is the non-obviousness. And non-obviousness is anyone that's got some knowledge in the field will say, I wish I thought of it before. They find it cool. There's like that wow factor. And when your application is with a patent examiner, let's say at CIPO, proving that it's new is fairly, I would say fairly easy. You've done your research, you've searched databases, scientific literature, you demonstrated that it does not exist. Fairly easy. A lot of work, but fairly easy. Useful, does it solve a problem? Yes or no? Where most of the negotiation between a patent agent or yourself and the patent examiner is on that non-obviousness factor, because your patent agent or yourself, they're representing you, so they want to obtain the broader protection possible. But then the examiner will say, yeah, but you know what? If you mix Article A, Article B, your solution becomes pretty obvious. So that's where they negotiate. So again, at the end of the process, once the patent is granted, you obtain a patent that protects your technology on the legal side and on the technical side to be able to detect and to signify any infringement on your patent. So a patent in itself is a full disclosure of your invention. And that's where sometimes clients will say, you know what, I don't want to file for patent because I will have to fully disclose my invention. To which we answer yes, but based on that full disclosure, Canada and any other countries where you applied for patent will provide you with that exclusivity to monitor infringement, also to say, you know what, you're using my technology, you owe me royalties, or we'll get into litigation because I really don't want you to use my technology, you know. So you have mechanisms, and of course, yes, it costs money, so you have to decide what kind of strategy you will want with your patent. But by and large, with that full disclosure, based on the three criteria, you will be granted that patent that will provide you exclusivity and the right to exclude anyone from selling, using, and manufacturing your invention. Um, and I say invent improvements. Today, 90% of the patents we receive are improvements on existing technologies. Think of the cell phone. I mean, for those who remember back in the early 90s, that a cell phone was super big and you needed your car pretty much to operate your phone, and it was super big, barely making phone calls and receiving them. Now, with millions of patents, we've improved and we're this really tiny, tiny device that pretty much holds our life, and we have different multiple applications. So there's millions of patents all through the years that have led us to have that type of cell phones. One thing to remember also, Canada and the States, based on that novelty factor, if there's any disclosure, by mistake or for some reason you've disclosed information, in Canada and the States, you still have 1 year to apply for patent protection. The danger is that some countries are zero tolerant against disclosure. And for Europe, for example, so if Europe was in your strategy and you disclose your invention, your information, it's too late to obtain patent in Europe. Some countries in the world do have some flexibility, like China, Japan, South Korea, and Australia. But by and large, the key word is don't disclose anything, or at least make sure you have proper agreements and you can trust people you talk to. So what can be patented? A product, let's say here it's a flying car. The process to make that flying car could be patented as well. The machine that manufactures those cars, and a composition of matter. So any composition to ensure the elements are helping that car to fly. So all these four elements could be patented. And again, it goes back to as long as they're new, useful, and non-obvious. And again, same as with trademarks, you have to understand, is patenting the right decision for you? Uh, when we talk to clients, we will say, you know, what is it that you have? If reverse engineering is fairly easy, doable, most of the time, you know, clients will go for a patent. Let's say you've got this toaster and you tear it apart and you understand the mechanism. Well, to protect the toaster, patent will be probably more appropriate. And again, if you don't patent for the right decision, for the right reason, it's perfect. When we're talking more like agri-food, like a recipe, sometimes trade secret is the best because it's not by the example I use, not by drinking Coke that you know the exact recipe and can replicate Coke in your house. So that's are the main like criteria to analyze, but there's more. Budget is absolutely one of them, but it's also are you ready to enter the patent world? It's very complex, it's very expensive, but again, at the same time, it's what provides you with your exclusivity on your targeted markets. So again here, yeah, do your research. Make sure that what you invented is new to the world, does not exist. And it could be complex because we're dealing also with information that could be available in a different language that we may not understand. So as best as you know, as best as you can identify if your invention is new, consider patenting. All around the world, patents are awarded on a first to file basis. It in some countries, and USA was the last one to to join that movement, but it used to be first to invent, which was very hard to detect and to prove. So now it's fairly easy. It's a first to file. So if you're in a very, very innovative space and you've got competitors developing similar technologies as you, it's crucial to find that filing date so that you're the first in the world to apply for patent protection for that specific technology. Do we have questions on patents before we move to copyright?
None that I
No?
see right now. So yeah, we're good to continue.
Perfect. So copyright will protect original work that could be literary or artistic. So a computer code, business plan, website, blog, choreography, a play, anything that's original. And copyright, as I've mentioned, is automatic upon creation. And even if you don't register at CIPO, you can always use the Circle C, your name and name of your company, depending on who owns the copyright, the year of production, and you can always add something like all rights reserved. If you file for copyright protection, you don't submit a copy of the work. You just provide the title, the name of the work, and some information like address, names, and whatnot. Then you get a certificate. The value of the certificate is that if in any case, or it comes into your copyright being infringed, uh, copied without your consent, if you decide to go into litigation, the judge in court will base his decision on that registration, because registration means that registration provides you with this stronger right to defend and to prove that it's your work, not the infringer's work. And that being the copyright holder also means that you can negotiate rights to reproduce your work. If you just wrote a super great fiction book and people really like it, then you can turn it into a movie, into a TV series, into a play, and in exchange of royalties. In Canada and in most countries in the world, it's the copyright lasts for the life of the creator plus 70 years, which means that going back to the question we had about the brother that was an artist, depending on when he passed away, but it's currently life of the author plus 70 years. So which means during 70 years after the death of the artist, the creator, his family, friends, whoever owns the forgot the word even in French, but whoever owns the work now will benefit from any royalties paid for this work.
And
The
question on
question.
yeah, copyrights. We've had a couple questions relating to developing a course or program. I'm
Hmm.
assuming it falls under copyright. Is that correct?
Yes, it could even become a trademark if the training becomes very popular. It could become a slogan, could become a trademark. But yes, by and large, training material is protected by copyright. The first point on this slide is very important, but it also applies to all the IP rights, as I've mentioned before. So the first author is not necessarily the copyright owner. If, let's say David hires me to draft a business strategy, 5-year strategy plan, the business links own the copyright. I don't, even though I'm the writer behind, because I was paid and I was hired to develop that business plan. If I write a book in the evening on my personal computer, then obviously I will own the copyrights. Um, and as a copyright owner, same as with a trademark or patents, industrial design, as the owner of the IP right, you have the duty to monitor infringement. CIPO will not monitor infringement and copyright and counterfeiting. It's you as the owner to do it, and you rely on your network of clients, collaborators, partners, especially around the world where it's more difficult for you to have an eye on every country's if you're present in different markets. So as I say, copyright will protect any original work, databases, source code. And again, source code, copyright protects the language, the text itself, not the functionality, which means if you develop an app with its specific source code, someone else could have a very similar app using a different language, a different code. So they're not infringing. If you want to protect the software, like the functionality, it would be more a patent, but it's very complex and it requires a lot of conversation because if you file for patent for source code, then chances are the source code will evolve, the functionality will be improved, there'll be new elements added to that app, let's say. So it would be to always file for new patents. So it may be very complex, very expensive, so may not be the best option. For software developers, most of the time, and I've talked to patent agents and they rely on the branding. Like they're the best. They were the first one to launch that type of app. They love the branding. They love the name. They love the logo. So the branding would be like a very good strategy to brand, to market, to launch an app or software. So same as for any other IP rights, being conscious of time, we have 7 minutes left. I have a few more minutes if needs be, but you can exploit your copyright on your own. You can grant licenses to other people to do it, and you can also sell your copyright to another individual to exploit it on your name. And of course, that's like a lump sum, or that's selling your house. You no longer own your house, it's someone else who does. Copyright infringement will go quickly because we still have, I'll go quickly on that one as well, but you can use some copyrighted material without infringing when it's called public domain, okay, or when it's fair dealing, when it's for education purposes, let's say, or when it's under Creative Commons. Okay, it's
And
very
if
long.
we go 5 or 10 minutes over, that's
Fine.
okay.
Yeah, I have a client at 2, well, at
Okay.
12 for you, but I told him I would be a bit behind, so that's fine. Industrial designs. Going back to patents, patents are all about functionality. Industrial design is all about visual aspect. What does it look like? Like the shape of your phone, the shape of the pen, the armchair, whichever is original could be an industrial design. In states, they're called design patents. And again, being granted an industrial design means that you have an exclusivity and you can exclude anyone from making, using, and selling that design. In Canada, it's up to 15 years from filing. And same as for patent, if there's any disclosure, you have 1 year to file to obtain the protection. Again, making sure it's original. Then the value, what's really cool with industrial design is, let's say you protect the shape. And the best example is the Coca-Cola bottle. When Coca-Cola designed that bottle back in 1915, 1917, it was very innovative. So they protected the shape of the bottle. 10 to 15 years later, industrial design protection expired. So they converted that into a trademark. So it's what we call distinguishing guise, which means that still to this day, sorry, Coca-Cola is the only corporation, only company in the world who can sell beverage in that shape of bottle. And think of it, if you see that bottle and there's no logo, you still recognize it. So that's the power of the trademark. So instead of having a design that would have been non-protected since 1930, still in 2025, 2026, it's still protected by trademark. So many elements that could be protected by designs. So the shape of the t-shirt, let's say, the configuration, where you put your elements, repetitive pattern, decorative element, combination of all of them, and different like the sunglasses, the seat, the ornament, the pattern on the fabric, the Converse shoes, the shape of the cell phone, many other aspects. Here you have a tissue sheet, the embossment, the toe cap for a skate, the way it's shaped, the shape of the blade under. All of these elements are protected by industrial design, and they're really day-to-day object, as you can see. Some more examples, the water filter. So in that case, probably there's some patents protecting the mechanism to filter the water, but there's also the way the filter is designed that's protected by industrial design. And there's more than likely a name. There might be a slogan. There's probably copyrights attached to users' manuals. So one single object may have different IP protection. Perfect. Okay, so trade secrets. Trade secrets are not protected at CIPO. It's a legal document. It's any information that's value to your business and that provides you with an edge over your competitors. So Coca-Cola recipe, a very specific recipe you're using in your business. One example, I'm trying to find examples also where it's not necessarily larger corporations. So I was in New Brunswick a few weeks ago, and someone's telling me about this small business in Moncton who was selling this, it's called Cheesehead, and they were really, really popular. Their clients were restaurants, were stores, but sadly, the owner passed away suddenly, and he never had the chance to pass on his recipe. So because no one had access to that recipe, the company went down and they went bankrupt not too long after. You should have, like, the best practice would be have that recipe somewhere in a safe in a locker, in a encrypted computer, whatever it is, so that at least someone has access to the recipe and you can maintain the activities after someone leaves the company or passes away, sadly. So there's no registration, sorry, and it will be protected as long as different parties having access to the information, maintain it secret by non-disclosure agreement, by confidentiality agreements, and there's always all kinds of mechanisms. And think of it as toothpaste. If the toothpaste is out of the tube, it's too late. You can't put it back. So the secret is out, probably not patentable. All your competitors will have access to that information and can use it to use the same product. So this is different ways to protect the trade secrets. So restrict information, record trade secrets, store them in secure location, encrypt, non-disclosure agreements, make sure your employees are aware there's a secret and they can't disclose to any other, obviously competitors or even friends and family. So I've mentioned this concludes the IP rights portion. So I've alluded to trademarks and patent agents. Uh, these agents are they practice in private cabinets. We don't regulate their fees. Uh, we don't regulate their fees, and we can't recommend an agent over the other, but we'll help you, somehow like making your mind on how to find a trademark or patent agents. They are people that have passed several exams. It's rigorous. If they're on the registry, it means that they're officially mandated to work in Canada as an IP agent. So I'll skip that because you'll have a copy of as well. So the QR code leads you to a form on CIPO's website to meet with an IP advisor, sorry, where we will go over your business project, identify IP rights that would be available for you and relevant for you, discuss funding, not finding partners, but different resources to help you conduct your business and scale up your business, protect your IP, obviously. So this is what we do. It's free of charge, as I've mentioned. Our mandate is to demystify IP. It's to help you save time and money. We have access to a large array of partners across Canada, federal, provincial, business incubators, business associations, etc. And we are national and we're free. So that concludes. Well, it's not stop sharing. I hope you find it useful. It's a lot of information, I know, but you're more than welcome to reach out to me and my colleagues and obtain information specific to your business.
Awesome. Thank you so very much, Caroline. That was amazing. Yeah, very insightful and practical information. We've
Thank you.
learned a ton about trademarks, patent, copyright, industrial design,
Mhm.
trade secrets, and kind of how anyone can move forward in protecting their idea. and strengthen their business. And yeah, hopefully today's session sparked some new questions and next steps for folks. Feel free to
Mhm.
book a one-on-one meeting with one of our business strategists here at Business Link. Um,
Mhm.
and Carolyn also mentioned you can book a free session with
Yep.
a CIPO agent as well. That opportunity is available, both completely free. And
Yes.
yeah, like I mentioned,
Thank you.
today's recording session was recorded, and we'll provide that in a follow-up email to folks.
And I'll send you the PDF version probably before 3 o'clock my time today.
Okay,
Yeah.
perfect. That's
So
great.
before 1 o'clock your time.
Okay, thank you for that.
Hmm.
And yeah, I know folks have kind of asked questions throughout, so
Hmm.
that's great. Thank you so very much for those questions. We are running a little bit tight on time. But yeah, those are some great questions from everyone. Thank you for that. And I think that's all for today's session. So thank you to everyone for
Thank
joining us
you.
here today and contributing to our webinar. Please take a moment to complete the quick feedback survey. Your input does help to improve our programming. And yeah, feel free to connect again with Business Link. We're happy to
Mhm.
help and work with you. I see Caroline has provided her email as well. So
Mhm.
feel free to reach out directly with that.
You
And
guys are based in Calgary, right?
we have offices in
It's-
Calgary and
mhm.
Edmonton,
Okay,
but we do service all of Alberta.
super.
Yeah,
Because
we
I'm
have some staff
planning,
throughout, yeah, in rural Alberta.
I'm hoping to be in Edmonton in the winter time, like so I'll let you guys know.
Oh,
Hmm.
yes, please. Yeah, definitely
Hmm.
connect with
Got
us. We'd love
projects.
to
Yes.
host
Hmm.
you.
Yeah.
Uh, Great. Well,
Perfect.
thank you so very
Thank you so
much,
much.
and have a great afternoon, everyone, and take care for now.
Thank you. Bye bye.